Good evening. My name is Brendy Vega. I'm the Assistant Planning Director for the Town of Wake Forest. Thank you all for coming to our ethics training for advisory boards.
Hi everyone, my name is Hannah Combs. I'm an attorney at Wyrick Robbins. I practice commercial real estate and municipalities law.
And I'm Sam Slater. I've met a lot of you. Hannah's going to lead the show tonight, but I'll pipe in at times with some additional commentary.
So, what are we talking about tonight? Ethics. Great. So in front of you, you have North Carolina statutory law, and you have a piece of paper you should be familiar with, the Wake Forest Code of Ethics. We will refer to both of these documents throughout the night. We'll also have them up on the slideshow, but I'm a visual person and like to have things in front of me. You don't have to sign it again either. So, why are we talking about ethics? Why does this matter? Does anyone want to take a stab at why this matters? This is an easy one, guys. So the town doesn't get in trouble, yeah. What else?
So that you don't get in trouble.
So that the attorneys don't get in trouble, yes. That's great. Anyone else?
Trying to reteach right and wrong, I guess.
Try and teach right and wrong, okay. Accountability. And transparency, that's great. Okay, so all of you serve on a board. That means that you represent the town. It's important as town representatives to understand your role. And it's important that the public have trust and confidence in the people who represent them. So, one thing I'm going to focus on a lot tonight is the hat that you're wearing. So some of you work in an advisory capacity and some in a decision-making role. So if you are an advisor, you're responsible for making recommendations. For example, the planning board makes recommendations to the Board of Commissioners regarding special use permit applications. And if you're acting as a decision maker, you're responsible for making quasi-judicial decisions. For example, special use permits, variances, and appeals. Can anyone, before I go to the next slide, can anyone tell me why it matters what role you're in? Does anyone have an idea?
Based on the type of hearing.
The type of hearing? Okay, why does it matter what type of hearing you're in?
Some hearings require presentation of evidence.
Presentation of evidence. Yeah, okay. All right, so the presentation of evidence, that's great. So whether you're acting as an advisor or as a decision maker is important because the rules that you must follow are different depending on whatever role you're acting in. And of particular importance is when you're acting in the quasi-judicial setting. So the North Carolina Constitutions and statutes mandate that everyone deserves a fair trial and an impartial decision maker in the quasi-judicial setting. Okay, and so I already heard this a second ago. Evidence is presented in the quasi-judicial setting. So when you're acting in the quasi-judicial setting, you have to ask, does the evidence show that the applicant meets the standards? Evidence must be competent, material, and substantial. In other words, it must be good evidence. It's a simpler way of saying that. So what if there's conflicting evidence or facts? It is your role as a board member when you're acting in the quasi-judicial setting to make a finding of fact. And that's when it's particularly important to be an impartial decision maker. Okay, so this is a lot right now. But this chart should help you act as an impartial decision maker. Before we go through this, why is it important that you're acting as an impartial decision maker?
Because you're representing the people other than just yourself.
Because you represent the people other than yourself, you represent the town, right? Anyone else?
So that you don't benefit from the decision that you're making?
So you don't benefit from the decision that you're making? Okay. Anyone else? Why is it important to have impartial decision makers? What if you're the person whose application is going before the board? Do you want someone who's already had... Fair, yeah.
You have to recuse yourself.
Okay, yeah, recusal. We're going to get there. So hopefully by the end of tonight, you should be able to know when you need to recuse yourself. Okay, so in front of you, we have a chart. Can everyone see this? Okay, so in the first column, we have legislative land use, and then below that, we have quasi-judicial hearings. One thing that I'll point out is you have the North Carolina General Statute 168-381D. All of you should have that in front of you. And then North Carolina Statute 168-388E2. This is important because these are the standards that you need to follow when you're acting in an advisory role versus when you're acting in a decision maker role or a quasi-judicial setting. Does anyone notice anything different between these two rows? I'll give you a hint.
There's a lot more requirements for the quasi-judicial.
There's a lot more requirements in the quasi-judicial setting, yeah. So that's why we're saying it's important to know when you're acting as an advisor and when you're acting as a decision maker, because the standards that you need to follow in the quasi-judicial setting are much more extensive. So no matter what setting you're in, you need to be concerned with whether or not you have a direct, substantial, and readily identifiable financial interest. When you're acting in the quasi-judicial setting, you also need to determine whether or not you have a financial interest in the outcome, but also you need to determine whether or not you have a fixed opinion prior to the hearing, whether or not you've engaged in undisclosed ex parte communications, whether or not you have a close familial, business, or other relationship with an affected person. We're going to go through each of those standards tonight, so hopefully by the end of this evening, you should be able to say whenever one of these elements applies to you. Okay. So, not only must you follow the North Carolina statutes, but you also need to adhere to the Wake Forest Code of Ethics. Everyone here has read the Wake Forest Code of Ethics, correct? Okay, great. So, it says, board members shall refrain from publicly advocating for or against discussing, debating, or voting on a decision in which they have a financial interest. So what do you think that means? When do you have a financial interest?
When you work for the company?
When you work for the company, okay.
If you own a piece of property that's involved in a decision.
If you own a piece of property involved in the decision, okay. Anyone else?
Something that would benefit you in some way.
Okay, something that would benefit you in some way. What if it benefits everyone in this room? Think it's the same thing? Okay. All right. So you can think about financial interests on a continuum. On one side, you have decisions that affect board members in the same way as any other citizen. A really easy example is the property tax rate. That affects everybody in Wake Forest. In a situation like that, you clearly would not have to recuse yourself. If you did, nobody would be able to serve. On the far right, we have a situation where the board member is the only person affected by the decision. For example, a special use permit for a board member's property. I think someone used an example of their property being subject to the application. That's a situation where you clearly have to recuse yourself. Unfortunately, most situations fall in the yellow area where it's not so clear. Fortunately, this is one thing that courts have defined. And the Wake Forest Code of Ethics also defines what a financial interest is. So under the Wake Forest Code of Ethics, a financial interest is a direct and identifiable financial interest of the board member in the matter before the board. In addition, courts have analyzed this issue, and they've come up with 3 factors that they look at. The first factor is the number of people affected. So how many board members are affected by this? Again, going back to the example of the property tax rate. If this affects everybody, that's probably not a problem. The extent of the financial interest. So is this a significant or an insignificant financial interest? Are we talking this is going to result in $10, or is this a $30,000 investment? And then finally, the likelihood that the financial impact will actually occur. So we're going to go through an example. A landowner submits an application for major architectural design review. One of the members of the design review board is a real estate agent who hopes to sell that same property someday. Must the board member excuse himself or herself? Does anyone have any thoughts on this one? No? Why not?
It says he hopes. Doesn't mean that he has a contract already.
He hopes.
I hope to go to a lot of places and do a lot of things, but that doesn't mean that will happen.
Yeah? Anyone else? First of all, before we even go to that, is this person acting as a decision maker or an advisor? Decision maker. And why does that matter? It's quasi-judicial, so we have to follow different rules and we have higher standards to meet. Okay, so since this is a quasi-judicial process, North Carolina General Statute 168-388E2, which is in front of you, applies. In addition, what else must the board member adhere to? We have the statutes, and then there's one other thing.
Probably.
I heard it back there. The Code of Ethics. So for all of these, we still have to follow the Code of Ethics. Okay, so when we're thinking about this, we need to consider the three factors. The first one, the number of people affected. So how many people are affected by this? One, the real estate agent. Okay, so that's a little concerning. It's only one person. It's not the whole board. All right, the next factor, the extent of the financial interest. We don't necessarily know the facts here, but presumably the real estate agent could make a ton of money off of this. Who knows? But then the final one, the likelihood that the financial impact will actually occur. And what did we say earlier?
And they hoped.
They hoped. It's unlikely. So this is not a scenario where you need to recuse yourself. So we talked about financial interests, but again, we're in the quasi-judicial setting. So what other standards must this person adhere to? What else do we need to have a discussion about? Financial interests, ex parte communications. What are ex parte communications?
Any communication outside of the hearing.
Yeah, big fancy way of saying any communication outside of the hearing. Okay, so ex parte communications. What else?
Business and family or other relationships.
Mm-hmm. Business, family relationships. Okay, and then the final one.
You already have an opinion prior to the
Yeah, so what if this real estate agent comes into this hearing and says, well, I already know I'm going to vote this way because maybe one day I'll get something out of this. Is that a problem? Yeah. And one thing that I want us to get out of the end of this is you don't have to memorize all of this. I know I'm kind of shoving it up there, but the point is you need to have a discussion. So if you even think that there might be an issue, just say it.
I'll add something on
Yep.
that, Hannah. So last time we did this, we had ex parte communications, but we didn't have undisclosed highlighted. And so we added that, and it was a discussion at the last time because ex parte communications are going to happen, and people are going to talk to you guys. This is complex and dense subject matter, and for us to all be in here and serving in these roles, trying to process it, people in the community don't know when you're an advisor. They don't know when you're hearing a QJ decision. They just want to talk to you. And you know, you're not always going to want to say, stop, I can't talk to you, or know when you should or when you shouldn't, and you want to be good citizens, you know, and representatives of the town. And so it's only a problem if it's undisclosed. And I've been in meetings in quasi-judicial settings where I get a sense that board members feel like they've done something wrong by having a conversation. And so they think, well, it was just kind of a little minor thing. I see the wheels turning, you know, and I probably don't need to say anything. Then it could become a problem because it's undisclosed. It's something that happened that informed your opinion potentially about this application prior to the evidence coming in at the hearing. And so if you tell us about it, it's recorded, it'll go on the record. You say, well, I was in the grocery store and I talked to so-and-so and they were pretty hot about this. I listened to them for a minute, and I kind of just tried to remove myself from the conversation because I knew it was coming up. Well, these are the questions you'll get from the attorney, right? Well, did that inform or fix your opinion prior to today? No, I will be impartial, and I can plan on continuing to be impartial. Then it's not undisclosed anymore. It's disclosed, it's on the record. You don't have anything to hide, and it very likely will not affect anything going forward. So I urge you all to not shy away from or be scared of ex parte communications, because they will occur. But sunlight's the disinfectant, and you just say what happened, and then it's not. I mean, then it's no longer undisclosed. Yeah.
Okay. The next factor we're going to look at is close personal and business relations. So Wake Forest Code of Ethics says, board members shall refrain from advocating for or against, discussing, debating, and voting on decisions when they have close personal or business relations with any party in the matter. What are close personal relations? Does anyone want to take a guess at that? Good friend or family member. Okay.
When you work for, say, you work for a construction company, you work on the design work for the project.
Yeah, that's a great example of a business relation. All right. I tend to think close personal or business relationships is kind of a vague, that could mean a lot of different things. But fortunately, the Wake Forest Code of Ethics define these for you. So close personal relations means a relationship involving the board member's spouse, parent, child, that includes stepchildren, sibling or in-laws. And then close business relations is defined as a relationship involving some person or entity with which the board member is associated for business purposes, such as an employer, partner, co-owner, or client for whom the board member regularly does work. Again, this says regularly does work. So if you did work for someone 20 years ago, that's probably not an issue. But even if you're not sure, bring it up. Let's have a discussion about it. And one thing I want to emphasize is that we are here to help you deal with these conflicts when they do arise. The sooner you bring them to our attention, the easier it is for us to address them. And not everything is a clear-cut answer. As you saw from the financial continuum, it's not always this is definitely a conflict of interest, you need to recuse yourself. We'll sometimes sit back at our office and we'll argue. Sam will see it one way and I see it the other way. But you need to have that discussion and get it on the record and show that you've dealt with these issues.
Question?
Yeah.
If I drive a concrete truck and then there's a project that comes before the board, I don't know if my company gets the concrete work or not. I don't own the concrete company, but I drive a concrete truck. If we happen to get the project to deliver concrete, does that fall under that category, or is that just so far removed?
I would say
I'd say
it's
no.
removed.
Yeah. I'd go back to the. I think of that as a financial interest, potential financial interest.
Yeah.
And evaluate it the way we looked at that earlier one, with something that affects everybody versus something that affects just you, certain to happen, likely to happen, unlikely to happen. And again, that's the kind of thing that if it's ticking in your minds and you raise it, it's always going to be better off to raise it and discuss it.
So the answer would be a little different if I own the concrete company and I have sort of a working relationship with certain developers in town and I get the bid, so that answer might be a little bit different than I'm just one of the guys that drives the trucks and delivers.
Yeah, I would certainly say so. If you drive the trucks, you're driving concrete all day, every day somewhere, because everybody needs concrete. But if you own it and maybe you don't have a contract on the project that's up for bid, but you do all that guy's work, and odds are you're going to do his work on this one too, then that's something to raise. Mm-hmm.
And it brings up a good point, because right now we're going through each factor by factor, but sometimes if you discuss all of them as a whole, it brings up other issues. So you could add, is there a financial interest here? Or another question would be, do you have a set opinion about this matter? So because you drive this truck, are you going into this hearing saying, I know I'm going to vote this way? If so, that's a problem. Anyone else? Okay. All right, so there was a case study, Cox v. Hancock, that actually dealt with familial relationships. So in Cox v. Hancock, a special use permit applicant was married to the aunt of the acting chairman of the city's Board of Adjustment. In that situation, the court held that the familial relationship did not deprive neighboring owners of due process. There was no evidence of bias. So again, are you coming into this hearing with a fixed opinion? Are you unable to look at this issue and make an impartial decision? And there was no evidence that he would receive any benefit from his vote on the proposed project. So is he going to gain anything from the situation? The court said no. The next issue in the Wake Forest Code of Ethics is the appearance of impropriety. Board members shall conduct themselves in a manner that does not raise the appearance of impropriety. What in the world does that mean?
It's all about perception.
Perception? What do you mean by that?
I mean, people don't necessarily need to hear all of the facts about something. If it just looks fishy, then they're going to think it's fishy.
Yeah, that's a good point. Sometimes we want to avoid situations where people think there's something strange going on. And again, that's why we encourage you always disclose. If you're putting it out there and you're putting it on the record, someone's a lot less likely to say, they were trying to hide something from me. That seems a little fishy. Yeah. Anyone else? So this one, really all you need to do is ask yourself, would a reasonable person in your position view this as a conflict of interest? So like you just said, is a town member going to see this and think, this is a little questionable, what were they thinking? What would a reasonable person do in that situation? Okay, we have another hypothetical. So a dentist owns property in a residential neighborhood and is applying for a use variance to use his property as a dental office. The Board of Adjustment is preparing to conduct a hearing regarding the variance. Before the hearing, one of the board members discloses that she went to school with the dentist and recently spoke with him about applying for a variance. Must the board member recuse herself? So first of all, just hearing this scenario, is there anything that sticks out to you that might be a problem?
Just the recently spoke.
They recently spoke, okay. Anything else?
I would say there's no problem unless it goes undisclosed.
No problem unless it goes undisclosed, okay. Ditto, okay. All right, so first of all, let's take a step back. Is the board member acting as an advisor or a decision maker? Decision maker. Yeah, this is a variance, so it's a quasi-judicial setting. Okay, so since it is the quasi-judicial setting, what standards apply?
The long list.
The long list, exactly. And what else? There's one other thing.
Post-personal relationship, post-business relationship, appearance of.
Yes, the long list, and then there's one other thing, the Code of Ethics. So in everything that we do, the Code of Ethics applies. All right, and someone kindly pointed out the long list. So what are some issues that you see here in this situation?
Undisclosed communication.
The undisclosed communications. Okay. Anything else?
Potentially a fixed opinion.
A fixed opinion. What if she says, you know what, I went to school with this guy and I'm gonna help him out here. Is that a problem?
Sure.
Yeah, big problem. Okay. Is there a family or a business relationship? No. No? Okay, and what about a financial interest? Probably not. Okay. And these are the things that we need to go through and we need to talk about each of them. Chances are, it's probably not going to be an issue. She's probably going to be able to say, oh, I can be an impartial decision maker here. This isn't a problem. And again, as Sam mentioned, the ex parte communications is not necessarily the problem. It's whether or not you disclose those communications.
What if you disclose your conversation with this potential applicant, and as the meeting goes on, it's clear that you are not impartial? What happens in that case?
So we're going to talk about recusal at the end. Can we hold that till then? I might call on you again to bring that up. It's a good example.
Well, I've got a real world example, of something that maybe I can bring up and it can help shed some light to this, which is sort of a really gray area even to me, but I was sort of going to the full spectrum on it. But I work at an architectural firm. And, a few weeks ago or so, we had another company that I guess is working in partner with us. And as they were preparing their package, they knew I was on the board, just because word travels no matter whether you want to or not. And so they asked me which sections do they need to look at. They were just sort of asking for some guidance within the ordinance of what to look at. They weren't asking me to review it. They weren't asking me to give an opinion on it. They were just sort of asking me to point out some of the things that they needed to look at. But I reminded them, hey, but this was where my boss was asking me to look at it for them. Now, this is something I'll bring up if the case ever comes in front of us. But at the same time, that's where you're sort of in between a rock and a hard place, where you're not the company owner, but you are requested to give advice on something. My first advice was, well, you need to contact the planning department, and they'll be able to answer all these questions for you. They gave the sections they need to look at, and kind of left it at that. How would that, that's, in my opinion, that's ex parte.
Yeah.
But it's not, where I've tried to guide them or give them a pre-approval or anything like that. I can be very, it doesn't matter to me whether they get it or not, But that's a real world example of what happened. And then, obviously I was going to the very end of the spectrum saying, hey, you're not supposed to be talking to me about this. And you really need to get off of the planning department, set a meeting with them. But it's going to happen.
Yeah.
That's one of those things that's going to happen, especially if you're in the industry that you're on a board for. So how would that be viewed? As long as that was brought up in the beginning, I was going to recuse myself anyway. But
You were going to because of
just because they had
financial interest?
Well, there's no financial interest to me.
Yeah.
Personally, but as long as we have enough board members there, I would let them know ahead of time that, hey, there's a good chance that I'm going to need to recuse myself because of this. That's, I guess, where you also need to let the rest of your board know. If you know you're going to have to do that, try and let them know ahead of time as well, right?
Let the staff know or the attorneys know, not the other board members until the meeting.
Right, that's what I'm talking about.
Yeah.
Exactly.
But I'd say you handled it well. That's a tough spot, right, to be in between. Your first instinct is the right one, which is to hear enough to know that it's not something you should be discussing and try to end the conversation politely.
And forward them to who they need to talk to.
Yeah.
Nothing wrong with doing that.
It sounds like you handled it very well. So.
That brings up the issue of the appearance of impropriety. I hadn't thought I handled it well, but that's a perfect way that somebody could think that it was improper.
And that's why you got to bring it up at the hearing, so that it's
Exactly.
on the record, so that if anybody reads the minutes, it's very clear right there that it wasn't something that was just discussed with us behind closed doors.
Right.
At the very beginning of that meeting, you bring it up exactly the way it was, and then decide then and there as a group whether everyone feels that you can go ahead and vote, or if you feel uncomfortable enough, you just recuse yourself if you have enough people that can still pass or fail the vote based on numbers, correct? Is that
Right.
fair to say?
Yep.
I think that's a great example of how to handle a situation like that. You point them to the correct resources, explain to them I'm on the board, and you disclose this communication. I think that's great. Yeah.
I would imagine, it doesn't matter, I would think, if you're stating matters of fact and statutes as opposed to just giving your opinion on what they're looking for.
Yeah, I think that was a good example. It sounded like you were pointing them to the resources.
Yeah, just point them to the steps that they
saying
need to
this
pay
is what you
attention
need to complete.
Right,
Yeah, there's a distinction between that and saying, hey, I know how to help you get this through, a lot of this is kind of common sense and going, I think you said earlier, like, does this feel icky? Does it stink? I mean, that's the appearance of impropriety. A lot of it we can go through on the statute, but part of it is just, would a reasonable person view that as a conflict or something that we need to be concerned about?
So if you're stating like matters of code, like it can only be
Yeah.
20 feet high, I mean, there's no conflict there.
But you'd want to disclose, if
Yeah,
you're,
still disclose.
yeah, but you'd want to disclose that you had the discussion.
You just don't want the email to pop up after the decision. It shows that you were involved with somebody or something.
Yeah.
Which is a lot easier to track that conversation, obviously.
Yeah, yeah.
But-
Because it's important as stewards of the town, but it's also important because these QJ hearings are legal proceedings. And so the advisory role, the advisory versus decision maker distinction, I think of that advisory role, and it's when our commissioners are hearing legislative cases. You're a congressman, right? You're elected. You're supposed to be talking to your people and your constituents and finding out what they want, what's important to them, where do they want to see growth, where do they want to see parks, all that kind of stuff. And you're supposed to bring that knowledge with you to the legislative decisions that you make. You can consider anything and everything practically in making those decisions, versus these situations where you're hearing a quasi-judicial decision. You're not a congressman anymore. You're an Article III federal judge, and you sit on the bench, and witnesses get called, and evidence gets presented, and you are supposed to come into that meeting with no impartiality. I mean, all this, the list of 4, it all comes down to no impartiality. You cannot come with your mind even slightly steering towards one side or the other. And so you keep that from happening by not discussing it, by not having a family member up there, by not standing to make money from it. But it's all geared towards ensuring impartiality as a quasi-judicial decision maker. And what got me thinking on that was the disclosures, and if the town is ever challenged on one of those decisions, that's going to be the nature of some of those challenges. Frequently is the nature of a challenge from an aggrieved party, a loser, someone that lost, that something got built that they didn't want to get built, or the town denied them something that they wanted. And if there can be developed through factual testimony or discovery that, well, that was his brother, and he never told anybody, then the town's probably going to lose on that appeal, and it's going to go back and be done all over again.
Whether you were right or wrong, you are able to say, guilty, not associated.
But potentially. I mean, you never know how it would go on an appeal, but those are the types of things that, if you're the attorney representing the party that lost, you would be thrilled to find out that that was the brother, because you've got a pretty good case.
Yeah, I mean, if you even for a second think, should I disclose this? The answer is yes. Put it out there. Because again, think about a situation where you find out someone had an ex parte communication. There's nothing on the record showing this communication. That just leaves the mind to wander. Oh, well, they probably discussed this. But if someone brings up and hears, oh, he had a conversation with them about this, and they say, oh yeah, he brought it up. This is what they discussed. This is what happened. That's a completely different situation than a situation where you didn't share it with anyone. People are going to start thinking, what is he hiding? What's going on?
And again, I guess it doesn't mean you can't vote. It just means whether you can still be impartial or not, more than anything. I mean, obviously, the extent of that ex parte can push that further in that direction to the appearance of something.
Yeah, it depends. You look at it, the totality of the circumstances. So not just one specific thing.
Right.
As a whole, is this a conflict?
So the example here, is this gentleman recused or not?
I would just to not have, not that I would be impartial either way, but again, just to try to not put the town in that position.
Well,
as long as we have enough board members that could.
Yeah, there's also, if you can be impartial, board members also have a duty to participate and vote. So you don't want to get so timid that everybody's just saying, well, I don't know, I'm just going to sit this one out, because that doesn't serve the town's best interest either. And so, as you've explained, I mean, to your question, it comes down to the mindset of that person, right? Can he answer? Because anytime you've heard us ask, the town attorneys ask Have there been undisclosed, have you had any ex parte communications? Well, yes, we talked about this. Okay, would that affect your ability to be impartial or to render an impartial decision tonight? Only you know that, right? And so that comes down, so it is your decision. I'll tell my Courtney story. Can I tell my Courtney story now?
It's good, yeah.
All right, this plays in right here. So I had a jury trial in Wake County earlier this month, and we were picking the jury on a Monday, and there was a room full of 38 people. They put the 12 in the box. It's called voir dire. You ask the jurors questions about them. If there's a reason for that and again, it's to find an impartial jury. I mean, the judge, Superior Court judge, is repeating all along this impartiality. You can't speak. I mean, the jury trial setting, lawyers, jurors don't talk to each other, don't say hello, eliminate all pleasantries. It's awkward and uncomfortable, but that's the goal, to ensure an impartial jury. And so there was one seat number 11, that had turned over a lot. It was late in the afternoon. It was still open. And someone came and sat down, and he introduced himself. He said, I work for this company. And the basic questions are where you work, if you're married, if you have a spouse or significant other, where they work. He said, my spouse works for the town of Wake Forest. And so I was sitting there like, there's a lot of people that work for the town. It's probably not anybody I know. And so a few more questions, and my co-counsel and I were at the table, and he said, and it came out that his spouse was in the planning department. And so I was like, his wife's Courtney, and I know Courtney. So the guy that was asking the question said, does anybody know any of the lawyers? Wyrick Robbins, does that ring a bell? He goes, well, no, that doesn't ring a bell, but Sam? I think he had wanted to serve, and then the judge asked him, he said, well, would your knowledge of Mr. Slater preclude you from being impartial? You know, would it cause you to believe him more than the next guy? And he answered honestly and said, yeah, I think it would. And so he was excused as a juror. Now the part that I chuckle about that is that I got to talk to Courtney, and so Courtney Jenkins is in planning department. A lot of you probably know her. And so I know that Courtney went home and told Tim, hey, there's this guy Sam working with the town. She either told him, he's fantastic and you should believe everything he says, or she told him he's terrible and you can't believe anything he says. But it was one of those two things for him to have a fixed opinion about me, because I'd never met him, but he knew who I was. So I just tell that story because that's the high stakes judge, jury, bailiff, court reporter, clerk, gallery. I mean, everybody's there to consider the evidence and render an impartial decision, and that selection process is a part of that. You guys are all selected, you know. But the mentality behind being a decision maker and remaining completely impartial, that's universal across these settings.
So what about, I was thinking that was fine until you just gave that example. What about people that you actually know that you've worked for before in a quasi-judicial hearing that are giving the evidence? Should I be disclosing that kid used to work for me? Or I used to play soccer, you know? So some of those, because of working for local government, there's a lot of people
I don't.
that I know.
The example I use is a little more extreme because a jury trial is a little more extreme. The courts recognize that, the case law recognizes that, and the statutes recognize that a quasi-judicial hearing, rules of evidence are relaxed. So it's not expected to be as extreme as the example I just provided. But again, if any of those relationships would affect your impartiality, or if it would lead to the appearance of impropriety, then you might raise that. You might just raise that at the beginning on the record. Just for the record, Mr. So-and-so, I coached so-and-so in a soccer team, and our children were teammates or whatever. I haven't seen him in a long time. We haven't talked about this case, but I thought the record should reflect that. And then the record reflects that, and it's done. Mm-hmm. Yeah.
Oh, I just wanted to go back to Elmer's example of the architecture firm. And so what if it was his architecture firm actually working on that project.
Well, and that's where this was tricky, where we're sort of consultants with them. Like, we're working in partner with them. If we had no work on the project, you know, I don't look at the project, I don't check the project, it's not even in my corner of work, but having that association and having been approached,
Right.
you know, that's where, you know, obviously, you know, I don't even know if that would even come before anymore, you know?
Yeah.
But that's one I flagged to make sure, you know, to bring up. And so that's similar to what you were saying, where you can sometimes just be walking down the street and somebody talk to you too, where it's not anything you invited. It's not like you're out, you know, publicizing this, but if people know, they're gonna approach you not knowing that you can't talk.
Right.
That's where you gotta educate them just as much. in
Sure.
that case,
Yeah.
right?
Yeah. No, I agree. In Brendy's hypothetical, if you are the architect preparing the application, you know, if you are, or the architect that is doing the design work that is going to go before the board, I think that's pretty clear. Yeah, yeah.
Right. But
And then
that's where
so,
mine's kind of great.
Yeah.
That's what I'm saying, where I just work with a firm that is involved in it,
mhm,
where I had no direct work with it, but I was approached.
mhm.
You know, and I try again not to give any advice other than here's pretty clear rules you need to adhere to. And if you have any more detailed questions about these rules, then my suggestion is you go to the planning department and seek clarification from them, because that's what their role is. Correct? I mean, is that?
Yeah. You agree, Brandy?
Yeah.
I mean, to reach out to the planning department? Yeah.
I mean, that's my first response anytime, anyway, so, because that's what you guys encourage too,
Yes.
for anyone, from my experience.
Disclose. All right. Anyone else want to add? Okay. Let's do another hypothetical. So a proposal has been submitted to rezone a specific parcel of land. The rezoning applicant is the stepchild of one of the planning board's members. Should the planning board member recuse himself?
Just disclose.
Well, I said earlier, that, I mean, it's that job.
But this is advisory, not
Oh,
decision
right.
making.
Okay, I've heard a few different things. I've heard stepchild, I've heard advisory. Okay. You both are correct. Okay, so that was great. The first question we need to ask, are we acting as an advisor or a decision maker? We're acting as an advisor, which means the lesser standard applies. So the main question there is whether there's a financial impact. But what is the one thing that applies no matter what scenario we are in? The Code of Ethics. And what constitutes a family relationship under the Code of Ethics? Stepchild. This was supposed to be a trick question, but both times we've done this, everyone has gone stepchild. So clearly I need to make it a little tougher next year. Okay. So earlier, someone asked about recusal, right? Okay, so how do I recuse myself? The statute says, if an objection is raised to a member's participation. This part is bold because the statute doesn't say if I raise an objection to my participation or whether or not another person raises an objection. So presumably you could recuse yourself or another member could raise an objection. And that member does not recuse himself or herself. The remaining members shall, by majority vote, rule on the objection. I highlighted shall because this is not an option. If an objection is raised, the potential conflict should be presented to the attorneys. Does anyone have any questions about recusal?
So I asked him at planning, right?
So I know one thing we talked about in the last training was if you do have to recuse yourself, where should you go? Where should you sit? What do you guys think you would do in that situation?
You know, so they're running in crowd, right?
Sit with everyone in the audience? Okay.
You could potentially participate as a witness or present evidence for or against. In some cases, right?
But just a slight twist to that, the board member discloses whatever.
Mm-hmm.
It's financial or whatever. There's no problem. I'm going to be impartial. Here's what I did. we just chatted about it, I didn't advise. And so therefore, he does not recuse himself. But then as the meeting goes on and the discussion is carried on, it's clear that this person is biased and should have recused himself. What then do you do? Does the attorney then step in and say, just a minute?
I'd say the attorney and/or any remaining members under that. Is that the chair, particularly the chair or whoever else senses that bias, right? That was purported not to exist, but it's pretty obvious does exist. That it's not too late to make that motion, at any time that there's a concern about objectivity.
Okay.
In a legislative case, though, is bias a reason to recuse yourself?
No. Yeah, that's a good point. Yeah. Under the code of ethics, the close familial relationship would be, and so you can equate that with a perceived, the town code of ethics is that's kind of a perceived bias with close familial or personal relationship, but just a feeling or a fixed opinion even prior to something in the legislative sense is not a violation.
And the goal is to raise these issues as soon as possible. And of course, don't ever feel like we didn't raise this right away, so we can't bring it up. Always bring it up, no matter when it comes. Of course, we want to hear it as quickly as possible, but if there's an issue, you need to raise it. Because again, the whole point of all of this is to make sure that the public trusts the government and what we are doing. Yeah.
You said that as soon as possible, so like the design review board, some of the architects do recuse themselves because they're presenting. Should they make that known before the meeting, and should they make that known to, I think the planning board kind of knows, but the town attorney, so that way they know, because the problem that we run into sometimes is we don't have a quorum if one of them is excused, so attendance now becomes critical.
I guess that was kind of what I was trying to come to my question with too, is that if that case was to come, before us, and you have like 2 week notice or whatever, then I would think that would be the time for which we need to let everyone know that, hey, there's this happened, this is, my stance on it, and then just kind of sit back and let the chair and the town, decide. Plus, just give everybody notice, like what Nick's saying, because you have to have, I think 3 at least, and we've only got 5 altogether, so.
That's right.
Sometimes some people can't make it.
Yep. So you get.
Is that the time to do that?
It is, yeah.
Every time anything ever comes up, we send an email to you guys and say, hey, this might be a possibility.
Well, the examples that both of you gave, the example you just raised was you're the architect on the project that's going before the board. Certainly, and raise that ahead of time and let the staff know and the attorneys know. All of our emails we'll show at the end of this. You guys can take a cell phone picture of it if you don't have them already. But email any of us about it. But then there might be a reason to make adjustments ahead of time.
Right, but we're discouraged from communicating between ourselves.
Yeah, so
right.
staff and attorneys.
And then you come back to us and say, hey, we
That's
need
right.
full participation because someone has to recuse themselves.
That's
So
right.
Don't include the other board members.
Don't include the other board members. Yeah. That's right. And this has come up in the DRB, and I can tell you my take on it is I don't think it's appropriate for a board member to present to the board. Right. If you are in an I understand it's a small town, and I know everybody is doing their best for their business and the town and their public service, but when you consider the appearance of impropriety and close personal relationships of people that serve on boards together, to sit there and have a board member who was in the seat next to you for the prior case stand up, turn around 180, and present to you for you to remain impartial, is a challenge, and that would be a challenge to defend, I think, were it to ever be challenged and taken up.
The suggestion of that is have someone else in the office.
So if you have, exactly, so if you have someone else in the office, that I think that's, you know, I know if you guys said no to any business that came before the DRB, you wouldn't have any business. And so it's a tough situation, but to have someone else from the office that is presented for you to recuse yourself and not participate, leave the room, sit in the back row, whatever, so that, you know, it really is as best it can be under the circumstances with the makeup of the board, a presentation of facts by the applicant and an impartial decision by the remaining members of the board.
So that goes back to one of the other comments, maybe not even being a witness or anything, or presenter really about anything.
Yeah. And if you think that can't be the case, I mean, those are those examples where if you're a board member, but you see the need or you sense that there's a chance you kind of become, in the QJ setting, a witness, a fact witness, or I'd certainly want to be able to gnaw on that a little bit before I show up that night.
Let me ask a question. This is kind of in the opposite direction of this, but I have seen this happen before in my past life, particularly in controversial special use cases, where a member of, in this case, the planning board, obviously, the planning board makes the recommendations, especially, they try to recuse themselves, and they don't really have a leg to stand on. I mean, and you mentioned earlier the obligation to serve. We have an obligation to vote when things come before us as members of advisory boards. What do you do in that situation? Does the rest of the board say, hold their feet to the fire and say, well, you do have to vote on this, even though you don't want to, and maybe you think it's going to upset your neighbors or somebody, whoever, people that you go to church with, or whatever the reason is you're trying to get out of voting? What happens? How is that handled?
So I don't, I think an open discussion is the most appropriate response in that situation. I don't know of a mechanism that someone who says, I'm not voting, I'm recusing myself, that they can be forced not to. But that recusal could cause, if there's not a basis for it, and that recusal could cause issues in itself in terms of participation, quorum, vote counts, and so, you know, that board member who thinks they're maybe helping themselves or whatever the case may be really might not be doing that and might be causing a much bigger problem down the line by doing that.
Well, I know in the case of the town board, if a board member doesn't vote on something, then it's considered a yes vote.
Right.
Is the same hold true for advisory board? If somebody doesn't vote, is their vote a yes on whatever the matter is before them?
If they're not properly excused or recused. And so what I don't know the answer to this, but you know, that line between, if a board member is properly excused, their non-vote is obviously not a yes vote, right? And so, but on the other side, on the other end of it, if someone shows up, they listen to everything, they don't try to get out, and they just don't raise their hand or say yay or nay at the end, it's a yes vote, right? Because they just didn't participate. But what I don't know the answer to is, you know, is there a way in that middle ground where it's a sham recusal? Does the law recognize a sham recusal? And what is the voting implication of a sham recusal?
You know, I guess, you know, in the comment, the first bullet up there, you know, it says if the member does not recuse themselves, this is the opposite of it, then the remaining members shall vote by majority vote.
Right.
Would the same apply in the reverse, where the person wants to be recused and nobody else thinks they need to be?
My initial instinct is it doesn't, but again, I don't, you know, the statute only talks about it in the one way, right? It doesn't consider it the other way.
Well, fortunately, it didn't happen much, and what we ended up doing was just let the person not vote and not raise a stink about it.
Right.
But it was very obvious
Yeah.
to just about everybody in the audience that that person really
Really-
shouldn't have recused themselves.
Yeah, right.
They just didn't want to vote.
Right. And there's probably plenty, particularly for planning board meetings, there's probably plenty of opportunities where a lot of members would like to be in a turtle shell for something, but
Could you just abstain? Is that-
if you
Yes or no, could you abstain?
if you abstain, it's a vote for yes.
Okay, abstain is a yes.
Yeah.
But the public might not know that, so if you
Yeah.
don't open your mouth, they may not catch on.
Yeah. Yeah.
Any other questions about the quasi-judicial setting? Okay, we're going to transfer and focus on advisory board etiquette. Okay, so advisory board members, this seems pretty straightforward, must act professionally. They should avoid personal criticisms, and they should respect the decisions of the board. One thing to remember is that any contact with the media in an official capacity should be reported to the town.
Brandy, who's the communications and public affairs director for everybody? Both? Yeah. Everybody knows that? All right. Everybody knows that? Just making sure.
I was going to say that.
Yeah.
All right, social media. Remember, going full circle here, you represent the town. Social media, we all love it, but it also can breed challenges, especially when you're acting in an advisory capacity. One thing that's really important to remember is that the North Carolina Public Records Law can apply to you in your communications on Facebook, text messages. So North Carolina General Statute Section 132-1, it says, public records made or received by public officers, boards, councils, there's a long list, in connection with a transaction of public business are subject to public access. So what constitutes public record is a lot of things. Papers, letters, maps, books, photographs, like I said, Facebook posts, text messages, voicemails. If you are dealing with public business, it's subject to the Public Records Law. So, one thing you should ask yourself, does this matter fall under my board's purview? Is this public business? And am I acting in official capacity? So what hat am I wearing? What am I doing? And am I just acting as my independent self, or am I acting as a board member here? An easy one is, are you communicating with town staff? That's going to be subject to public records. There are certain exceptions, but those deal with legal matters, criminal investigations, trade secrets, and things you're talking about on Facebook, right? So refrain from using social media to communicate with town employees about town-related matters, subject to the Public Records Law. Do not speculate or repeat rumors. And if you know of something that should be used in a news release, contact the Communication and Public Affairs Director. Another thing about social media, it's an opportunity for you to set an example. So when you're posting on Facebook, again, you represent the town. So the way that you handle situations on social media, Twitter, Facebook, whatever, it's an opportunity for you to show others how to behave. So you can direct other social media posters to appropriate town resources or staff. So earlier you said the example, you said contact the staff. Same thing with social media. And if there is an issue and you're unsure of some sort of communication or something that happened, raise it. Okay. Any social media questions?
Yes. The town has an app called See Click Fix, which if you see standing water, a pothole, fence falling down, which you sort of presume to be negative because it shouldn't be that way. I'm assuming it's fair for me to report it to See Click Fix, but am I reporting a negative something?
No, that's that's okay.
Okay.
Yeah, but good question, yeah.
But it's like negative comments or negative opinions is kind of what you're talking about, right?
Right.
Yep, and I think there's a distinction between reporting something on an app and posting a Facebook post saying, I've complained about this hole and the town's not doing anything about it.
And I'm on the board.
Yeah.
Think they listen to me?
Yeah.
Who's running that show?
So the big thing that just came through the news with Wegmans coming in, it was all over the news, it was all over social media that Wegmans was coming, and the planning board hadn't heard it yet. So one of the things that I posted was, upon review by the planning, or, by the town, and because lots of people were posting and they're like, oh, it's coming and it's coming here and it's coming. I was like, when approved, like that's all I wrote on it, because it was just ticking me off to see every paper in the area and every social media in the area saying that it was happening. I was like, when approved? I mean, that's all right? I mean, it's been approved now. I didn't say that I said that on the meeting before. I didn't disclose that. But it was just one of those things that everyone assumed it was going to happen, but it hadn't been approved yet. So I was looking at more as educating people that it's not there yet.
My response would be, I completely understand the mindset and the interest in posting that, but I would just not. You got just center.
You're just inviting more discussion about it.
Yeah, and I mean, it just the range of outcomes on that is from kind of like nothing to maybe not so good, right? There's not a whole.
The response was the planning board approves everything. So.
Yeah.
Well, that's what I'm saying.
No, they don't.
I didn't apply that.
Yeah, there you go. All right, good. That's good. Discretion.
As
Yeah.
soon as you do anything, any trolls are going to come out. And
Right,
try to
right.
make you into something else too.
Yeah,
So,
yeah. I mean, we all know how these
Yeah.
message boards and environments work and
everybody's
devolve to
empowered behind the keyboard.
the lowest base, thing.
I can tell you as staff, what we do as staff in those situations. We do not respond to them.
Right.
If Bill Crabtree contacts one of us and says, there's a conversation, I want to put out a response, then he'll ask, what's the real story? And then he puts it out as a communications. So things have been brought forward. I know somebody here in the room brought forward that a resident was speaking poorly of the board and a decision that they were going to make, speculating that they were going to rubber stamp it. And we brought it to Bill's attention. And I can't remember in that case if he said no need to respond, this is a agitator anyway, or there's certain people that just pick on every item coming before the board.
And he has a list in his office of those people, so he knows
Yes.
to look for them.
Well, and I mean, it's got to be a tough position too for a lot of the commissioners who, they get a barrage of negative emails whenever, before and after.
Yeah.
And, I mean, that's got to be a even harder position than any of us can imagine.
Thick skin.
Yeah.
Yes.
In the old days before social media, staff used to die when somebody would write an editorial to the Wake Weekly about something we had done wrong.
Yeah.
And their first reaction is, I want to respond to this person.
Yeah.
My philosophy and my order was, don't ever respond to an editorial, because all that does is then they have to say something back, and then, suddenly you're in this debate.
Yeah.
And I said, you never win a debate in the news media.
Yeah.
And it's the same with social media now. Best thing to do is just bite your lip and
Yep,
let it
leave it
go.
alone.
And the Bill Crabtree, I mean, avenue is really good, right? Because, and you all have that, everybody has that, to be able to report it like we talked about, and explain, no, I really think there's a real issue with this, and there's a real misconception around what's happening, and just a short little press release that can come from the town and be linked on this message chain could be really effective. And then, that's what he does, and those are the decisions he makes. And then it's vetted, and the town has a unified message, right? And not talking heads talking past each other or saying different things, because that unified message is really important.
Well, that gives you a buffer of protection too. Right?
Yeah, certainly. Yeah, that's true, yeah.
I was gonna say, I wish I had a personal Bill Crabtree, like, talk to him, talk to Sam.
Is it safe to assume that really for the purposes of this, there's no distinction between your personal postings and your role? I mean, I'm thinking of a situation, I'm on the Historic Preservation Commission, something comes before me, personally, I'm not a fan. But it went through the proper process, it met all the requirements, I maintained my impartiality, and it passed. And something comes up in a neighborhood posting group. Oh, I don't like this thing, and I go on and say, well, I'm not crazy about it either, but it was properly done. There's really no distinction between me as a commission member and a personal.
Not in that example, I would say. Yeah, I would agree. Yeah. No, that's right.
And I said earlier, it depends what hat you're wearing, but you got to think to the public eye. They always see you as the board member. I think that's just the reality of the role that you're in.
Well, I mean, in that case, you're trying to sort of help them understand, but really you're just sticking your own neck in the noose, to do something like that.
And I think it's especially difficult for the Historic Preservation Commission, because it is only a small area of town that you're looking at, and everybody kind of knows each other. and so I think that's probably, in my opinion, the most challenging board to sit on.
As you suddenly become mute.
And maybe that's a good thing.
Any other questions?
Any other questions or comments about anything we've touched on tonight?
And again, our email's up here if you need anything.